Ladies and gentlemen, your attention, please. Welcome to Jimmy at the Crossroads, as it's Free to Choose Friday. On this Free to Choose Friday, we're talking about upholding the Second Amendment, even in the Ninth Circuit, with Jimmy Sengenberger and Professor Randy Barnett. Stay tuned. Jimmy at the Crossroads with Jimmy Sengenberger is next.
And that, my friends, is how America was made great once again. Breaking at this hour, Jimmy Sengenberger is currently at the crossroads of politics and economics. Radio broadcaster master, now the celeb on the web. He's the smarty of the party. He's in cahoots with the grassroots. Jimmy at the Crossroads brings you thought-provoking commentary, hard-hitting interviews, original satire, and the best bumper music known to man. Jimmy at the Crossroads!
Gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix, I said. Gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix. I got Jimmy at the Crossroads, making sense out of nonsense. People want answers, they want to understand. They come to the crossroads and Jimmy gives them the plan. I said, gonna talk money, gonna talk politics, great for all generations. Oh, what a great mix. I got Jimmy at the crossroads, making sense out of nonsense. Come on, Jimmy, what you got?
Hello, my friends, and welcome to another Free to Choose Friday edition of Jimmy at the Crossroads. I'm Jimmy Sengenberger, your host for the program. Once again, coming to you in partnership with the Washington Examiner, bringing you engaging, intelligent talk and doing our level best to make sense out of nonsense. Such a pleasure and a privilege once again to be with you today. It is Free to Choose Friday. It's a glorious Friday here in Denver, Colorado. It's beautifully sunny outside, and I'm glad you're along for the ride. If you have not done so already, please subscribe to the YouTube channel, youtube.com/Jimmy at the Crossroads. Also, follow me on Twitter, like the Facebook page, and check out the website, JimmyAtTheCrossroads.com, where we've got all of our content, we've got articles, and so much more. Check it out, and be sure to check out the shop, too. Some pretty cool stuff there as well. Plus, do not forget, please go ahead, subscribe, follow, like, all those good things to our friends at the Washington Examiner on YouTube, Twitter, Facebook, and, of course, at WashingtonExaminer.com. Once again, so great to be with you. It is indeed Free to Choose Friday. Today, we're going to focus on the constitutionally protected right to keep and bear arms enshrined in the U.S. Constitution. It truly is a remarkable document. The Constitution itself and the Bill of Rights, they limit the power, size, and scope of the federal government. We're going to talk about the Second Amendment and its significance with Professor Randy Barnett of Georgetown Law Center. He's going to join us, and we're going to dive into this topic. He's done a lot of research. He's filed a lot of amicus briefs, so much work. He's a true expert on the Second Amendment. We'll get his thoughts on the importance today of the Second Amendment, and we will get his thoughts on the decision by the Ninth Circuit Court of Appeals last week on the Second Amendment that was pretty darn stunning, that's to be sure. Now, I have some thoughts I want to share on the Second Amendment, but first, Free to Choose Friday. Why do we call it Free to Choose Friday? Well, a couple of reasons. One, we believe in America. You are and a right ought to be free to think, free to act, and free to choose. And our patron economist, and we usually talk economics, not always, but usually here on Free to Choose Fridays, is Milton Friedman, the late great economist who published a book called Free to Choose, a seminal work of economic and liberty literature, and also had a show, a television series that was on in 1980. And as we do every Free to Choose Friday, and especially because Nathan Matuse just loves its retro vibe, let's play the intro to Free to Choose when it was a TV program. Good old Milton Friedman, who was a big advocate for the idea that coercion needs to be held in check. The role of government, as Milton Friedman strongly advocated for, as we advocate for here on Jimmy at the Crossroads, is fundamentally to protect the rights of the individual, which are fundamental, which are God-given, which are inherent as human beings who can think, who can reason, who can act. That's why you have rights in the first place. That's why you have property rights, which are so critical, so important, and so fundamental. Basic building blocks to a free society. Milton Friedman talked about this in Cut 2. In one of his talks that he gave, and he did so many wonderful speeches, he talked about the fundamental principle of a free society, and we cannot discuss the Second Amendment and our constitutionally protected right to keep and bear arms without knowing what the fundamental principles of government are and ought to be.
The fundamental principle that I am going to try to uphold was stated by John Stuart Mill in On Liberty over 100 years ago. The only purpose for which power can be rightfully exercised over any member of a civilized community against his will is to prevent harm to others. His own good, either physical or moral, is not a sufficient warrant. That's the fundamental principle that I am going to take as a given, as describing my own values in trying to discuss the question of what government's role in a society dedicated to promoting freedom in that sense, what its role is.
We need to keep that in mind as we have our discussion today about the constitutionally protected right to keep and bear arms. The reason why I want to talk about this is twofold. Number one, last week we had a significant decision. Significant because it came out of the Ninth Circuit, which has been notoriously anti-constitutional in so many ways, with rulings that do not show the kind of reverence and respect for the Constitution that our judiciary should. But thankfully, President Trump has been reshaping the judiciary in remarkable ways. Before he took office, there was an 11-seat Democrat appointee majority in the Ninth Circuit Court of Appeals in California, which is notorious for being sort of out of whack. As Mike Davis put it, he's the former guy behind the scenes who handled the Judiciary Committee stuff in the Senate, particularly the Kavanaugh proceedings on the Republican side. And he's absolutely right, out of whack. Well, now Democrats have a 3-seat appointee majority. That is to say, only 3 more judges on the Ninth Circuit were appointed by Democrats than by Republicans, which is truly remarkable, but it's bringing the Constitution back into view in our judiciary. That's one of the great hallmarks of the Trump presidency. But what's so significant about the decision is that it came from the Ninth Circuit Court of Appeals and it was right on. We'll talk exactly about what the decision entailed, what their ruling included from Judge Lee, who wrote the opinion, later with Professor Randy Barnett. But fundamentally, they struck down a law in California that limits magazines to 10 rounds. As unconstitutional, they struck that down. Now, let's keep in mind the importance of the Second Amendment that we're going to get to today. It's the second item on our agenda, and the one I want to start with, though, in this conversation before we get to Professor Barnett. And that is, right now, we have had across the country riots, destruction of property, looting. You remember we covered in depth the riot that broke out at a pro-police rally on July 19th, right here in Denver, Colorado, in downtown Denver, just blocks from the state capitol. A peaceful gathering broke out because Antifa and socialist extremists, supposedly representing Black Lives Matter, literally swarmed this 6th annual event, starting fights, whacking a guy like Ron, you see there, in the head with a longboard, engaging in other violent activities and preventing us from being able to speak or even play music, for crying out loud. And guess what? The police stood there and did very little. They made one arrest. It was basically after the event that they brought out the pepper balls. And I think only 2 or 3 were fired that day. And not only that, but the police, who were predominantly standing there, they were told to retreat. I want to play a clip. This is from my 710 KNUS radio colleague, Peter Boyles, did an interview several weeks ago with the police lieutenant who oversees the police union, Nick Rogers. And he made a startling statement about what the police were ordered to do when this violence had broken out and things were getting a little too testy.
I'm sorry on behalf of the rank and file. That's not us. That's not who we are. And it just kills me that we let good people down. And I'll be honest with you. As I've done my due diligence, I did discover a couple of things. I found out that a retreat order was given by the incident commander. And we had one lieutenant step up and said, "We're not leaving." And this lieutenant said, "These people are going to get killed if we don't stay." So he kept his group there. And that's the only reason this thing didn't even get worse, because somebody broke ranks.
Somebody broke ranks. They were ordered by local police to retreat and not to defend those who were speaking out once again for the 6th year in Civic Center Park, downtown Denver, Colorado, standing up for the police. That's because the police's hands are tied. Now, yes, there are instances where the police have gone too far. We've talked about that on this program, where excessive force has been used. George Floyd is an example of that. There are other instances, including in the Denver metro area of Colorado, to be sure. But that doesn't mean that you tie the hands of officers so much that they cannot do their job. Well, as a result of this, and look, I'm here, we're in Aurora, Colorado is where I live. And in Aurora, we have seen not only riots break out, and we're anticipating on that happening this weekend when you have an anniversary of a tragic death in the hands of police of a man by the name of Elijah McClain. And some extremists have taken this as an opportunity to do this destruction that you see on the screen right now. That's the courthouse in Arapahoe County, in Aurora, Colorado, which is in Arapahoe County. This violence just a few weeks ago broke out, and not only did they destroy buildings, damage the property, use plywood as shields from the buildings that had been boarded up, but they controlled intersections, telling people they had to turn around, do U-turns. Those are not police turning people around. Those are so-called protesters. There's one story that was presented in a letter to the Aurora City Council from a man at an intersection at Alameda and 225, a major highway in Denver, where he and a number of other cars were blocked from being able to get onto the highway by these so-called protesters. And the man opened the window, this guy who wrote the letter, opened the window begging these so-called protesters to let him get through or at least turn around because his little girl had been waiting to go potty for 20 minutes, really had to go. Can you please let me go? And the guy used profanities and said, you don't care about black people? That's an example of how extreme things can get. So I bring this up because in these tense situations where you're building your property, your home, your business, your family, your car, when that is under attack, you need to be able to defend yourself. Because if the police have their hands tied to the point where they are not allowed to do their job, then you have to be able to take your self-defense in your own hands. And ladies and gentlemen, that means exercising your constitutionally protected right to keep and bear arms. It doesn't mean to use it unless you feel it's absolutely necessary. It means to be able to protect yourself and be ready. And what it means also is that the government shouldn't arbitrarily limit your magazines to a small number of rounds under the guise that that's going to work in preventing certain gun violence, while not tying your hands as a property owner or as a person trying to protect yourself and your life when you may need more rounds. Who is the government to step in? That's the point of this Ninth Circuit ruling in Duncan v. Becerra and why it's so important to allow people to exercise their right to self-defense enshrined in the Constitution, but it is a natural right because we are and of right ought to be free to think, free to act, and free to choose. And that means you have your own property in yourself and your things. And you have the right to protect it. And you should. And we must defend that right. And that's why I want to talk about the constitutional protections enshrined in the Constitution. With our guest in just a moment, Randy Barnett, professor at Georgetown University Law Center, as we dive into this topic of the Second Amendment and the Duncan v. Becerra ruling. Because, folks, it's essential, it's fundamental to being a free human being. And we must not lose sight of that. In fact, we must recognize it to the fullest extent we can. Because it gets to the core of who we are as human beings and as Americans. And that's why we're focusing on this topic today. I'm Jimmy Sengenberger. You're watching Jimmy at the Crossroads, coming to you in partnership with the Washington Examiner. And I know Mr. Matoush has a video break ready, but I see that our guest is already on with us. So why don't we shift gears to our special guest today here on Jimmy at the Crossroads and dive right in to this very important topic on a Free to Choose Friday. Randy Barnett is a professor at Georgetown University Law Center of Legal Theory. He is the author of numerous books on the Second Amendment and other constitutional issues. And I'm so pleased to be joined by Professor Barnett right now here on Jimmy at the Crossroads, again, coming to you in partnership with the Washington Examiner. Professor, welcome to Jimmy at the Crossroads. It's good to talk with you, sir.
Well, it's good to talk to you too, Jimmy. I hope our video connection is okay.
It seems like we're so far, so good. So far, so good. And I appreciate it very much. So I know you caught some of my monologue there. I wanted to lay it out for a moment why it's so important, especially in this moment, that we recognize, acknowledge, and defend the constitutionally protected natural right to keep and bear arms. To lay that forward and also talk about some of the fundamental principles and precepts. What do you make of that argument?
Well, this country was founded on the proposition that first come rights and then comes government to secure their rights. This is actually in the Declaration of Independence, which says we hold these truths to be self-evident, that all men are created equal, endowed by their Creator with certain inalienable rights, among which are the rights to life, liberty, and the pursuit of happiness. And then the next sentence says, to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So government exists to secure our pre-existing rights, and the right of self-defense is one of those pre-existing rights. The right to keep and bear arms is a means, an essential means of facilitating our right to self-defense. That's one of the reasons, that's the reason why it was put in there. It was also put into the Constitution because it's one of the rights that had frequently been denied to people by authorities. Such rights, the importance of such rights are always, such rights are always important because it's always the case that government is not going to be able or may not be able to come to your rescue if you are in a dire situation and are being attacked. But it is particularly the case if government itself denies that it has any responsibility to protect you and actually encourages or facilitates people who are going to deny you your rights and defunds the police who are supposed to be there to protect us. So nothing could illustrate the fundamental importance of the Second Amendment than what we've been witnessing in the last several months in Portland and other cities.
Police backers weren't.
Yeah, I think that's so well put and very true, and especially the notion of the pre-existing rights. We have a cut. This is cut 3 from Antonin Scalia, cut 4. Antonin Scalia, the late Supreme Court Justice who was noted for writing the Heller ruling of the Supreme Court. This is what he had to say about this notion of a pre-existing right, talking about the language of the Second Amendment.
The Second Amendment refers to it as though it were a pre-existing right. It didn't say the people shall have the right, or even the government shall not take away arms, but rather the right of the people to keep and bear, as though it was a pre-existing right. And that triggered historical inquiry that takes you back to the English Bill of Rights, which sure enough contained the right to keep and bear arms. As for the prologue, are they going to know what the prologue is? You know, a well-regulated militia being necessary for the defense of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Again, if you studied history, what's the connection between not taking away arms, the right of the people to keep and bear arms, and the militia? It seems very strange. But historical inquiry shows you what the connection is. The way the Stuart kings, the Catholic kings, destroyed the militia, which was supposed to be all of the male citizens trained to arms. The way they destroyed the militia was not by abolishing it. They just took away the arms of all of those who opposed the Catholic kings. And so there is a connection. A well-regulated militia being necessary for the defense of a free state, a militia consisting of all of the body of the citizenry, comma, the right of the people to keep and bear arms shall not be infringed. It makes thorough sense if you understand the history.
So that's Justice Scalia, the late Justice Scalia, and I'd love for you to sort of add to what he was saying and breaking down the actual language before we get onto this Duncan v. Becerra ruling, which is so fascinating to me, that decision. Let's keep on this conversation. Let's talk about the language used in the Second Amendment, Professor.
Sure. Well, for one thing, it includes a right to keep arms, which is to have arms, and to bear arms, which is to carry them. It isn't just keeping arms; it's keeping and carrying arms. So that's a really important distinction. They're two different things, and they're both protected. The argument that is made by some that the term bear arms was a military usage. It was a military term that referred to bearing arms in a military force. First of all, there are counterexamples to that, so it's not as strong as it seems to be on first blush. But secondly, there's no such argument made about keeping arms. That was not considered. There's no evidence that, or very scanty evidence that might have been in the military usage. Of course, it was used in the military context, just the way all words are used in a military context, in addition to a civilian context. So that's an important part of the wording of the Second Amendment. And the militia clause that precedes it, the militia preface or preamble, states one of the principal purposes for the right to keep and bear arms, and that is the preservation of the militia, which, as Justice Scalia correctly said, was thought to be conceived as the body of citizenry as a whole, not what was called a select militia, which we would now think about as the National Guard, but the citizenry as a whole. And in fact, U.S. law, the U.S. Code, still identifies a distinction between the organized militia, and they associate that with the National Guard, and the unorganized militia, which is everybody else. And that's in U.S. law, even up to this day.
Now, in terms of well-regulated, though, let's talk about that for a moment. What exactly did that mean at the time? And one of the most important things to keep in mind in this discussion is why we say at the time, because this is the intent of the Second Amendment when it was put into the United States Constitution. And that intent really cannot and should not be changed over time.
Well, first of all, when we're talking about a state law like we do in the Becerra case, it's not literally a Second Amendment case. It's a 14th Amendment case. And the 14th Amendment says, and that's not how the Becerra case was decided, because that's not how the Supreme Court deals with it. But we have to concern ourselves with the original meaning of the 14th Amendment to figure out what are the privileges or immunities of citizens that no state may abridge. Which is what and that uncontroversially included the right to keep and bear arms. People left, right, and center agree that the people who wrote the 14th Amendment meant by privileges or immunities certain fundamental guarantees, and a primary example of that guarantee was an individual right to keep and bear arms, not a collective or militia-based right, because in fact, the problem in the South that they were trying to address were the problems of militias, white militias, hunting down, lynching, and persecuting free blacks, as well as Republicans or anyone else who would sympathize or do business with free blacks. And so both the meaning of the Second Amendment and the meaning of the 14th Amendment both need to be assessed. But the meaning of the 14th Amendment really is really the most important between the two of them when we're talking about a state law. When we're talking about a federal law, like in Heller, the District of Columbia versus Heller, because the District of Columbia is a federal entity, then the Second Amendment is important, and the 14th Amendment doesn't really apply.
So the decision of, and let's shift gears over to this decision then. Again, we're talking with Professor Randy E. Barnett, who is professor of legal theory at the Georgetown University Law Center and also director of the Georgetown Center for the Constitution. They do begin by noting the Second Amendment, though, in the decision, in the ruling that came down from the Ninth Circuit in Duncan v. Becerra. So how did they interplay both the Second Amendment and the 14th Amendment in this decision? What was it about, by the way?
All right. Well, so it's a good question. What happened is that because the Privileges or Immunities Clause of the 14th Amendment was all but eliminated by the Supreme Court in 1873 in a case called the Slaughterhouse Cases, ever since then, the courts have used other clauses to apply or protect fundamental rights. And in particular, they use the Due Process Clause of the 14th Amendment to incorporate the rights that are expressly in the first 10 amendments, including the Second Amendment. So via the Due Process Clause of the 14th Amendment, the Second Amendment gets applied to the states. And at that point, courts just talk about the Second Amendment. I do think that's a problem because the evidence about the meaning of the right to keep and bear arms is even more powerful with respect to the 14th Amendment than it is with respect to the Second Amendment. But they're completely consistent with each other. So that's the reason why a court of an inferior court, a court of appeals inferior to the Supreme Court, would follow Supreme Court precedent and talk about it in terms of the Second Amendment.
And so in this decision of Duncan v. Becerra coming out from the Ninth Circuit Court of Appeals, so that means that there was a decision in the lower federal court, and then it was appealed to this panel. The panel took it up, 3 judges. It was a 2-to-1 opinion. Judge Lee wrote the opinion. It was centered on a 10-round magazine limit in the state of California, which was obviously struck down in this decision. Why would they do that? It seems like to some that the 10-round magazine limit would be very much appropriate because you don't need 10 rounds to go hunting. You shouldn't need to have more than 10 rounds on a regular basis, they say. So it's a reasonable limitation. What was the argument that Judge Lee presented that countered that point?
Well, before we get to what Judge Lee presented, let me give you my take on the reasonableness of that regulation. I live in the District of Columbia. I have my concealed carry permit there. I am limited to 10 rounds. DC has the same 10-round limit that California has. And so this actually affects me personally. I can't own a firearm that'll carry more than 10 rounds. Now, why is that arbitrary? You used the word arbitrary, Jimmy, in the setup for this, and that is exactly the word that I would use. Why is that limit arbitrary? Well, I give you as Exhibit A the fact that the District of Columbia, as well as the California statute, exempts law enforcement from this limit. They exempt police officers, they exempt off-duty police officers who have their service weapons, and security guards and other private individuals, some public and some private individuals. So the question we must ask is, what do they need more than 10 rounds for? And the answer is obvious. If you ask anybody, of course, they're going to say, well, they need more than 10 rounds for self-defense because the police and private security guards, they're not allowed to attack people. They're only allowed to use firearms when we're allowed to use firearms in reasonable self-defense, defense of their lives. You're not even allowed to use firearms in defense of property in most jurisdictions. Some of your jurisdictions you are, but mostly you have to be in fear of great bodily harm or have someone else be in fear of you're in fear of someone else being subjected to great bodily harm. So why do law enforcement need more than 10 rounds? Well, there's lots of reasons for that. And I'll give you some of them. Number one is you don't hit everything you fire at, unlike TV. Well, actually, unlike TV, people don't necessarily stop attacking you when they're struck by a bullet. You have to hit them a certain way at a certain time. There was recently a video of a female officer who tried to stop a male aggressor against her. And he was hit with multiple rounds. And she emptied her 15-round or 16-round service semi-automatic into this individual before he finally went down. If she had been limited to 10 rounds, she would have lost that fight. That was a one-on-one contest between an individual aggressor and a police officer. And therefore, it is arbitrary to limit our capacity to protect ourselves when the very same limit is not imposed on others. In this case, government police agents, as well as private security guards. That's why I think the 10-round limit is demonstrably arbitrary.
I think that's very well put. And in fact, I have a clip. This is cut 5 from the United States Senate hearing in the early 1990s. You'll recall, Professor Barnett, I will not, but you will recall that in 1991, there was a mass shooting in Texas, and it was at a restaurant in Texas. And there was a young woman who lost her 2 parents in that shooting, and she told her story before the United States Senate, Susanna Gratia-Hupp, and she specifically addressed this very point about a round limit in a clip. Take a listen.
Now, I'd like to make something clear. I hear all this talk about how many bullets can go in a clip. I've been there. I can tell you it doesn't matter. It takes 1 second to switch out a clip. You can have 1 bullet or 100 bullets. It doesn't matter, guys. I've been there. He goes, dump, dump, just like that. That's not enough time to rush a man. I promise you.
And that's firsthand testimony from someone who lost both of her parents in a mass shooting, Professor Barnett.
There is a third reason. I gave the first reason is that you don't hit everything you aim at. The second reason is you don't stop somebody with 1 shot necessarily. The third reason is multiple assailants.
Right.
And in fact, it was that third limit that Judge Lee relied upon or cited when he was discussing the irrationality, the arbitrariness of a 10-round limit in restricting the exercise of a fundamental right. And what is that fundamental right? He maintained, following the Heller case, that the fundamental right was the right to self-defense and the right to keep and bear arms.
Yeah, make no mistake, that is certainly the case. But something else that fits in is right now we have, and you alluded to this before, I was talking about it before, we have had businesses that have been absolutely looted and decimated with the only possible way in some cases for business owners to deter criminals, these vandals, from coming in is to provide for their own defense. We had a business owner in Raleigh, North Carolina on this program, Rick French, and he shared the story about how he had to have his nephew, who I believe is a law enforcement officer in another city, come because the police were literally nowhere to be found for about 36 hours, if I recall correctly, in Raleigh, downtown Raleigh, while it was being absolutely decimated. And he came with a couple of firearms, including an AR-15, and that was the only thing that could deter them from doing more than destroying the windows. And imagine if you have people who not only are coming in to take your property, but are also trying to do harm to you in those situations. We've seen beatings happen amidst these riots of some of these so-called protesters who were the rioters, beating on innocent older people, elderly women even, trying to stand up for their own property and say, go away. You need to be able to defend. This is real world stuff now, Professor Barnett.
Absolutely. And I thought Judge Lee did a very nice job explaining why it was real world stuff and why we must be realistic about a magazine capacity limit of the kind that California is imposing on the rest of us while not imposing it on its own police officers. However, I think we need to talk a little bit about how likely it is that this panel opinion is going to survive and protect this right in California.
Yes, and so but before we do, let's talk about the specific argument that Judge Lee put in his decision over the case of Duncan v. Becerra in the Ninth Circuit Court of Appeals. For example, he discusses common use of certain firearms and so forth. What is the argument that he presents fundamentally as why this needed to be struck down?
Well, the Heller case says that you can't possess all weapons. The right to keep and bear arms is not a right to possess any weapon whatsoever. It's a right to possess weapons that are in common use. In the case of Heller, it was handguns. There used to be a big handgun prohibition movement in this country. You don't hear about that so much anymore because people focus on the AR-15 and so-called assault weapons instead. But handguns is a category of weapons in common use. And what Justice Scalia and a majority of the Supreme Court said is you have a right to a weapon, an arm that is in common use. So Judge Lee had to ask whether a high capacity firearm, which by high capacity, we simply mean more than 10 rounds. And in the case of most semi-automatic handguns, we're talking about 16 or 17 rounds. In the case of an AR, it's usually up to 30 rounds. But he had to ask whether that was a weapon in common use. And what he said, citing statistics, it is that firearms that handle more than 10 rounds are the prevalent type of firearm. Magazines that hold more than 10 rounds, there are in this country, they're in common use. And that's what gives rise to the Second Amendment protection. You then have to ask whether a restriction on magazine capacity is a reasonable regulation of that right. But the threshold question is, do you have a threshold right to a weapon that is in common use? And in this case, it's a weapon that holds more than 10 rounds.
And this all, too, one thing that's important to keep in mind, and this goes to the clip we played of Justice Scalia a little bit ago, Professor Randy Barnett, our guest from the Georgetown University Law Center, that is the historical significance of this constitutionally protected right to keep and bear arms and what was intended at the time. Because, look, I mean, you consider what a musket was at that point in time as far as common use firearms, and you compare it to firearms that are available today, and you can understand why they would even use muskets in a military context, yet people would own them themselves. And then that's how they were able to take their own firearm to go participate in winning freedom for the United States of America. And I think that all too often we see ourselves just discounting everything that they experienced back in 1776 and 1787 at the times of the Declaration of Independence, the Constitution of the United States, and later in 1791 with the Bill of Rights. we discount that for some reason as though it's archaic, and now our firearms have changed, and therefore that means that all of the circumstances have changed with the Second Amendment and how it should be applied. And I think that this instance of the decision in Duncan v. Becerra from the Ninth Circuit Court of Appeals is a reassertion of why we even have it in the first place, going back, way back to 1776 and our initial freedom.
And 1868, Judge Lee pays full attention to the needs of free black business with free blacks, or who would have the temerity to vote Republican, to keep and bear arms against militias, and that is also discusses. We should also talk about changed circumstances. Which I don't think we should be. But you can't just limit a change of circumstances to the deadliness of weapons. You have to also include the effectiveness of safe people who were hit by bullet. In an extremity, you could die of infection because infection was untreatable, and in fact, many casualties in the war were as a result of what we would consider to be non-fatal wounds, but which could not in those days. So there has been an escalation in procedures to save people's lives if they're shot, but I don't think we should get into any of these things. Only that you can't get into some without getting into the others.
So let's talk about the significance of this decision on the national stage. The Ninth Circuit Court of Appeals, this was a 3-judge panel, 2 judges who determined in the majority that this statute in California should be struck down, limiting magazines to just 10 rounds. But it's possible that it could be brought up in an en banc panel, which I think it's the whole of the court, or a significantly larger number of the court. You can clarify that for me, but it's possible that this could be turned around even before it might head on to the Supreme Court. So what do you think the implications are of this, and will it stand?
Well, we have won, that by we, I mean gun rights advocates, have won arguments in the Circuit Court of Appeals before. And then only to have those arguments reversed by what you've correctly referred to as an en banc review. Now, it used to be that an en banc review meant a review of all the judges in the circuit. But the Ninth Circuit is too big to have all the judges in the circuit sit on a particular case en banc. So as a result, they designate 11 judges, circuit court judges, to be the en banc panel. And that's happened next. When California seeks en banc review of this Court of Appeals panel's decision. And the dissenter in this case, who was a district court judge from Texas sitting by designation in this case, the dissenter laid out a roadmap for an en banc, in fact, even mentioned the en banc panel to follow in order to reverse this decision. So it'll all depend on the makeup of the en banc panel. We can get back to that in a minute. But let me just say that if the en banc panel reverses the circuit court's opinion, I think it's highly, highly unlikely for the Supreme Court to then take the case to reverse the en banc panel, because the Supreme Court has shown us in this term that it does not want to hear additional Second Amendment arguments, and it's going to let the lower courts pretty much do what they want.
Well, and Professor Barnett, I talked with Ilya Shapiro of the Cato Institute about this when the Supreme Court declined 14 cases. There were 14 cases before the court to try and settle differing opinions from across the country. We have a patchwork of different understandings of the Second Amendment and constitutional jurisprudence around the country, and that yet the court hasn't taken it up, which I think underscores your point. Why do you think that is, especially when you have a 5-seat so-called conservative majority?
Well, we do have a 5-seat conservative majority, but one of those conservatives, at least one of those conservatives, Chief Justice Roberts, is a judicial restraint conservative of the old school, which means his basic philosophy, although he makes exceptions for this like all restraint people do, his basic philosophy is to defer to legislatures and not to invalidate what's referred to as popularly enacted legislation. In the case of the California ban, it was actually a popular referendum that strengthened a statute that had been passed by the California Assembly. And so I think that Chief Justice Roberts seems disinclined to be very aggressive, if aggressive at all, in protecting right to keep and bear arms against popular legislation that's passed by legislatures. That's a conservative position, or at least it was the conservative position before the rise of originalism within the conservative legal movement. Prior to that, most political conservatives considered themselves to be advocates of judicial restraint. And I just want to say the irony here is that the first people who proposed judicial restraint were the progressives leading up to the New Deal. So those conservatives essentially have adopted the progressive approach to the role of judges in protecting our fundamental rights.
What's interesting, though, is when we're talking about fundamental rights and actually having the court intervene, that's protection, I would say, of rights that are enshrined in the Constitution and being overridden. That is the Constitution, the supreme law of the land, and being overridden by statute. And it's, in this case at least, restoring back to the original intent, hence why originalism became something that conservatives really adopted more vigorously, because they recognize we have to protect these unalienable natural rights that are guaranteed and enshrined in the Constitution and in the Bill of Rights. That's what the founding fathers had intended, what the framers thought was necessary to include in these amendments and in the overall Constitution, depending on the particular issue at hand. And I think that is critical. And I don't understand at this point in time, when we've seen such an erosion of constitutional liberty, Professor Barnett, how that old sort of more conservative mindset on these types of issues especially is taken hold so much, especially in the mind of Chief Justice John Roberts, who's a very intelligent guy and also clearly is very familiar with the ideals of originalism.
Well, he's not an originalist, for
Yes,
one
he's not.
thing,
That's right.
and he's old enough to be the old style judicial conservative. But let me just say, it's a very interesting story, Jimmy, and it's a complicated one. And I wrote a whole book about just this story, and it stemmed from my experience as one of the lawyers in the Obamacare challenge who devised the argument that the individual insurance mandate was unconstitutional. We got 5 votes that our argument was right, but we didn't have 5 votes for actually invalidating the statute because we lost Chief Justice Roberts. He agreed with us that we were right, that it was unconstitutional to make you buy insurance, but he figured out a way to defer to the legislature by changing the law so that it wasn't really a mandate. I wrote a whole book to explain how this happened and why it happened. It's called Our Republican Constitution, Securing the Liberty and Sovereignty of We the People. It's my trade book, which is aimed at a general audience. So if anyone wants to know how we got ourselves into this position, where a conservative Republican like John Roberts could come out against the Constitution or enforcing the Constitution in the Obamacare case and would likely do so again in the right to keep and bear arms cases, you have to read that book.
Now, real quickly, this is sort of a detour, but since we're talking about John Roberts, one of my arguments, and I agree with the judicial restraint notion of that more classically conservative view of the courts, but I also think, Professor Randy Barnett, that a lot of what Roberts looks at is in the Obamacare case seems to be an indication of this, in my view. He also looks at this sort of from an institutionalist standpoint. That is the idea of, let me protect the institution of the Supreme Court, particularly from public perception that might make our status within society a little more diminished if we are challenging and overturning popularly approved laws. And I go back to the switch in time that saved 9 when FDR was saying, hey, we're going to pack the court, we're going to pack the court. He ends up not packing the court, but the Supreme Court suddenly does an about-face and starts upholding various New Deal laws, legislation that they had been previously striking down, New Deal legislation, and they started upholding New Deal legislation. It's known as the switch in time that saved 9, helped to prevent the packing of the Supreme Court at that point in time. And I think that was an institutionalist notion that was embodied in this idea of the switch in time that saved 9, and that John Roberts is sort of carrying on, at least to an extent, a sort of legacy of that. What do you make of that thought?
Well, first of all, I want to agree with you about the institutionalist point. I think that's exactly right about him. On the other hand, in my book, I explain why the switch in time that saved 9 story is actually not accurate. In fact, the switch had begun earlier It actually involved a justice named Roberts, Owen Roberts. It had begun earlier, and it took longer to happen than in just that instant moment. And it's a result of appointments to the Supreme Court that took place over time when presidents would appoint judges that were more friendly to progressive legislation as a result of the politics of the day. So the change happened, but it didn't happen just that way that story tells it. I will say, though, let's get back to the main point, the institutionalist point, because I agree with you about that. Because I think it's called the Roberts Court, we're in trouble. We're in more trouble. If he were an associate justice and not the chief justice, I think he might be doing different things as an associate justice. But because the court is named after him, and he's concerned with the legacy of the court, because he's concerned with his own legacy. Yes. He wants to preserve his legacy. And he identifies with the court. And as a result of that, he wants to get the court out of the crossfire, out of the political crossfire that ruling and upholding the Constitution would put them in the middle of.
And I would say it's not just because of the idea of the Roberts Court, but he thinks as Chief Justice, he has this sort of fiduciary responsibility to stand for the institution of the court. So a very fascinating discussion. I want to wrap up by getting back, though, to the Second Amendment and the significance of the Ninth Circuit Court of Appeals decision in the context of the sort of reshaping of the judiciary that we're seeing under President Trump. When President Trump took office, my understanding is that there were 11 more Democrat-appointed judges on the Ninth Circuit Court of Appeals than Republican-appointed judges. And now it's just 3 more Democrat-appointed judges than Republican-appointed judges on the Ninth Circuit, which has been known to be a very liberal, the most liberal Circuit Court of Appeals in the country. Talk to us a little bit about how you think this decision by Judge Lee and the other conservative judge on the Ninth Circuit helps to underscore what's happening in the broader changing mosaic because of President Trump's judicial appointments.
Right. The composition of the judiciary is changing now the same way it changed back before the New Deal. A president is elected who has a certain view of what kind of judges should be put on the bench, and a Senate is there of his own party. This is what FDR had. A Senate of his own party is there to ratify those choices, and that is how the court changes over time. It's the way it's designed to change over time, and it has, because Donald Trump happened to win the election of 2016. It's going to change more again if he does not win re-election in 2020. Not only that, but the Democratic Party platform specifically calls for expanding the number of lower court judges so that more judges could be put on the bench by a Democratic president and presumably confirmed by a Democratic Senate. And it identifies litmus tests on such issues as abortion and other cases that those judges must pass before they're put on the bench. In other words, expand the court. This is the court packing scheme that Roosevelt proposed for the Supreme Court. Expand the number of judges, so you can flip these circuits back. They're not all flipped in a conservative direction yet. The Ninth Circuit is 16-13. But that's what we have in store for us if Joe Biden wins the election.
And Kamala Harris, the vice presidential nominee now, she was just formally nominated this week at the Democratic Party, has explicitly said this too, and I think she would even like to see the Supreme Court expanded to more than 9. Now, why do you think that's problematic, Professor? The idea of expanding these judicial appointments.
It's not constitutionally problematic because Congress has changed the number of justices since the very beginning. We started off with 6 justices. Then to 5, then it's been as many as 10. Then it's been at 9 for a very long time, however. But there is a problem with a principle of expanding the number of justices because you don't agree with the justices who are on the bench, because you want to politically pack the court with justices that you agree with. Frankly, if this had been a permissible move, then the Republicans could have done this. And why didn't the Republicans do it? And what would the Democrats have said if the Republicans had done it with a Republican president and a Republican Senate? In order to do this, however, they're going to have to abolish the legislative filibuster in Senate, block this sort of thing from happening. And that is something else that many Democrats favor these days. which is going to allow them to implement a lot of their program in a way that Republicans have been unable to do because Republicans have maintained the legislative filibuster.
Very interesting. Professor Barnett, any final thoughts before we let you go today? And I really appreciate your time.
Well, it's a pleasure to be with you, Jimmy. I just urge people to buy my book, Our Republican Constitution, but also
Absolutely.
I have a new book called An Introduction to Constitutional Law, 100 Supreme Court Cases That Everyone Should Know. And that book explains the history of constitutional law. It's not about the original meaning of the Constitution. It's about what the courts have done about the Constitution from the founding until now. And if you buy that book, which is about $23 on Amazon, you get a link to a 63 video series that my co-author Josh Blackman and I created to watch. And it makes all of these cases come alive. It's like taking a course in constitutional law without having to pay tuition for Georgetown Law.
And why would anybody want to go to Georgetown Law? Oh, so they can actually interact with Professor Barnett, although I'm getting to do that right now here on Jimmy at the Crossroads. Professor Randy E. Barnett, yes, indeed. Check out Our Republican Constitution indeed as well. And then, of course, Professor Barnett is director of the Georgetown Center for the Constitution and professor of legal theory at the Georgetown University Law Center. Also, our second Bradley Prize winner to be here. We have had Dr. Walter E. Williams on the show, and he, like Professor Barnett, is awardee of the Bradley Prize from the Bradley Foundation, which I just think is such a treat. Professor Barnett, thank you so much for your time today. I really enjoyed the discussion.
My pleasure, Jimmy. This is the first broadcast I could do from my new Zoom equipment that I have gotten so that I can teach my classes all by Zoom this fall.
Perfect. We got to break it in. I love it. Professor Barnett, Thank you so much, sir.
Bye-bye.
Take care. Once again, Professor Randy Barnett joining us, one of the leading scholars on the Second Amendment and that constitutionally protected right to keep and bear arms right here on Jimmy at the Crossroads. Really just so many different angles and aspects to this discussion. And sometimes when you get somebody who really knows what they're talking about in these areas, you get off in whatever direction. And that's part of the fun. I want to play a clip as we wrap up here today on this Free to Choose Friday of Milton Friedman in 1970s, early 1980s, probably in the 70s. And he talked a little bit about the moral value of using force to help instead of voluntary exchange.
Whenever we depart from voluntary cooperation and try to do good by using force, the bad moral value of force triumphs over good intentions. And you realize this is highly relevant to what I am saying, because the essential notion of a capitalist society, which I'll come back to, is voluntary cooperation, voluntary exchange. The essential notion of a socialist society is fundamentally force. If the government is the master, if society is to be run from the center, what are you doing? You ultimately have to order people what to do. What is your ultimate sanction? Go back a ways. Take it on a milder level. Whenever you try to do good with somebody else's money, you are committed to using force. How can you do good with somebody else's money unless you first take it away from them? The only way you can take it away from them is by the threat of force. You have a policeman, a tax collector.
So I wanted to play that clip because what Milton Friedman underscores, and of course he's our patron economist here on Free to Choose Fridays on Jimmy at the Crossroads, what Milton Friedman underscores is the centrality of voluntary cooperation, voluntary exchange. That's the nature of a free society. Not just economically, although he's talking about that, but also in terms of your everyday life. It is not all about just using force. Now, you do need to use force. In essence, the threat of force is there to get somebody to pay taxes. But let's talk about the violence that we have seen in the streets, the looting, the rampages. Those are from people who literally, we have video of F property. That's what they were shouting as they were decimating, I think it was Aurora, Colorado, my hometown. They were decimating this city down at the courthouse. And they were yelling F property, F property. This shows that they don't give a damn about the idea of property rights. We already know that because of all the statues that they've been destroying. But they don't care about property. They will take it using force. They will destroy it because they think they can and should, or whatever's going on in their mind. They're not just wanting government to have the threat of force presented. They are genuinely using force, and you need to be able to defend yourself, not to take initiative and be aggressive, be the aggressor with a firearm, but simply to be able to defend yourself, your family, and your property. They are not advocates of voluntary exchange and a free society. These extremist thugs are all about destruction and stealing, taking what they think should not belong to you. Now, I wonder what they would say if somebody went up to them, grabbed an iPhone out of their hand, and gave them a pad of sticky notes, and on the top it said, F property. And then they just ran off with the cell phone. They might not be too happy about that. And all these people, of course, have state-of-the-art iPhones or Android phones. But they believe that for other people, the rich or whoever is the oppressor, that they can just take anything and not have to worry about it. We've seen the extremists beat on people, beat them up, without any care whatsoever for that person's rights. Because it's not about rights. This isn't a movement advancing rights. On the far left socialist end, the Antifa types, they're not genuine advocates for any sort of cause or for the advancement of human rights. In fact, they are against individual rights and want to trample upon that, and that's why they act the way that they do. This is why the Second Amendment is so critical in our society, especially today. The constitutionally protected right to keep and bear arms for self-defense. For the very reasons that Milton Friedman was talking about, both in this clip and earlier when he talked about the fundamental principles of a free society. We must keep this in mind as we move forward into the rest of 2020, into the election cycle, and on into the future, lest we lose our liberty because we fail to recognize, as Thomas Jefferson once said, that eternal vigilance is the price of liberty. That is it for us today here on Jimmy at the Crossroads. My thanks once again to Professor Randy E. Barnett of Georgetown University and the Georgetown Center for the Constitution, to Nathan Matoush, producer extraordinaire, working the Matoush magic once again here producing for us, and to our friends and partners at the Washington Examiner, as well as to you for watching, subscribing, sharing our content. Please share, and everything else. All of your support, we appreciate it. Be sure to tune in tomorrow night, 5 to 8 p.m. Mountain Time on News Talk 710 KNUS for the Jimmy Sengenberger Show. We will be back next week with more engaging, intelligent talk, Sang style, here on Jimmy at the Crossroads. In the meantime, have a great weekend, and may God bless America.